Good morning to all of you, and thank you again for joining us from around the world. I'm Christian Zeller, and this is our student visa and other COVID-19 visa update. I'm really pleased to report that for one, I can actually give you good news and not always bad news in those times. And so let's get going with this presentation and talk about the good stuff for a change. All of you students and all of our institutions know, of course, that we had this student visa ban, which was looming over our heads. And then on July 14th, just a couple of days ago, on the lawsuit filed by Harvard and MIT, Judge Burrs said the following. I'm going to recite, and you can read all of that for yourself, but these are the actual words of the judge rescinding the current student visa ban. And here is what that is. The most important sentence in this whole thing is that what the judge said, they will return to the status quo as established by the March 9th, 2020 policy directive and the addendum issued on March 13th, 2020. And that is probably the most important part of that decision. Now, what that means is, that anything that the administration tried to put in place has been rescinded. However, how do we move on? And I think that is important for all students, and that's also important for all the institutions. It's really the March 9th and the March 13th directive, which you will have to be governed by. And here's what that means. If your school is closed because of the pandemic, or if your school does not intend to reopen for the fall semester, then the student remains in the SIVIS system as an active student, just as it would be a summer break. And of course, we assume that at some point in time, the school is going to reopen by online classes, by a hybrid model, or by a full in-person classes. Now, the second example that was given in the March 13th memorandum was the school is closed and it offers online classes only, or some type of other tuition, and the student is in the United States. So if you're in the United States and your school is closed but offers online classes, then you continue to attend these online classes and you remain active in SIVIS. As you know, as a student, normally you can only attend one online class and you have to otherwise maintain a full course load in person. Here you are exempt from that. Another important part of that is, of course, if your school, and now I'm speaking to the DSOs and institutions, if that's what you're planning for the fall, that you offer online classes or a hybrid model only and not full in-person classes, then you must notify SCVP within 10 days. That's the original March 13th guidance, and you are bound by that. And then the third scenario that we have is that your school is closed and classes are being offered online, and you, the student, you are actually outside the United States. And again, the March 13th guidance applies, and that means you may continue to attend classes online, you carry your full load online, and you will be kept active in the SIVIS program. And once again, if that is what the circumstance at the institution is, the institution must report that to SIVIS within 10 days. And that's really it in a nutshell. There is nothing else to it. You can find this March 13th guidance online. It's posted on the SCVP webpage. It's on the ICE webpage. All you need to do is Google that, and you get the actual wording of the March 13th guidance. And as you well know, originally we had scheduled this webinar to talk about what happens if this ban is in place, and now it is not. So we're basically done talking about the student situation, and I have some other good news that I wanted to share with you, and then put you up to date with other things that are happening. And then we'll go to questions and answers. And as always, the way you do that is somewhere on your screen, you'll find a button where you can raise your hand. So please do that if you do have questions. And once you're called on, just unmute yourself and ask your question. Further good news, embassies and consulates are reopening. As you know, they have suspended routine visa operations around March 20th, and now they have what's called a phased resumption of routine visa services. And the reopening is really going to be post by post. And, I can't tell you about, the 200 plus posts we have around the world as to what their specific plans are. Of course, those plans are contingent upon COVID-19 country conditions in those various areas. Of course, the safety of our consular personnel. So there are no specific dates. What I can tell you is just yesterday, in the course of our regular business, we found out that, for example, the post in Cairo, Egypt said we're not reopening, but we will do so at the end of September. We also found in the course of our business yesterday that apparently our posts in Mexico have reopened, and that's not just the embassy in Mexico City, but also the consulates in Monterrey, Tijuana, Ciudad Juarez, and the others. And the webpage of the consulate gives no indication of that, though. However, there's also nothing on that webpage that says that it would be closed. So there seem to be normal operations in Mexico. We have word from our embassy in Vienna, Austria, that it has reopened and that it is providing limited visa services for certain purposes. So if you have a visa issue, of course, then we got to contact that particular post and see what their phased resumption of routine visa services is going to look like. Now, ESTA, of course, is not affected by that because, as you well know, those of you who have applied for ESTA, ESTA does not run through the consulates. It does not require an appointment. So if you have a valid ESTA, notwithstanding COVID-19 travel restrictions, you may be able to travel. If you do not have an ESTA, you can try to apply for it at this time. Another important thing is we have many clients, and maybe some of you have applied for visas previously, and then the appointments were canceled because of the COVID-19 situation, and you have already paid your MRV fee, the machine readable visa fee. So if you have paid that, that's going to be good for 1 year. But keep in mind, if you paid that in Germany because you had an appointment in Frankfurt, then you can only use it in Frankfurt. You could not use that in Rome, Italy, for example. So the MRV fee needs to be used where it has been paid. Now, in addition to that, although there's a phased resumption of routine visa services, please keep in mind that all 5 presidential proclamations continue to remain in effect. And the 5, you all already know what those are. Most of them have to do with the travel restrictions. The first one came out in January when the president stopped travel from China to the United States. Subsequently, another proclamation stopping travel from the UK, England, Ireland, and all the Schengen countries. Subsequently, further restrictions from Iran and Brazil. So the next proclamations were, of course, the visa restrictions first for immigrants and then for non-immigrants. And that is something I think that I want to revisit so that I can tell you what you can actually get at an embassy or consulate and what you cannot get there. What our consulates are saying is that emergency visa appointments are available. And the emergency visa appointments, of course, have to do with the visa restrictions. So just by way of review, the visa ban, the first visa ban we had on April 22nd with a presidential proclamation where all immigrant visas were stopped. So if you did not have your green card interview or immigrant visa issued by April 22nd, you were not allowed back stateside, except you were the spouse or child of a United States citizen, a healthcare worker, or an EB-5 immigrant, an investor employment creation immigrant. And then we had the second proclamation, and that extended the first proclamation to the end of the year. And it restricted entry for anyone who didn't have an HL or certain J visas issued. By the way, if you have an H-1B1, H-1B, those are not excluded because those can come in, and the H-1B ones based on bilateral trade agreements that the US actually has with Chile and with Singapore. So there are 5,400 every year that go to Singapore and 1,400 to Chile. So if you have an H-1B one, you can certainly come in. And the exceptions were, of course, under that second proclamation, the healthcare workers, anything COVID related, and so forth, and the national interest, economic recovery. So with that, let's continue to talk about the reopening of the embassies and what you can do. So under these phased visa processes, one of the things that's being done are the things that are in the national interest. Remember, we have in previous webinars, and you have seen in memoranda and presidential proclamations, you have seen all these exceptions that are in the national interest. And those are really being taken seriously by our consulates and embassies. So if there's anything in the public health, of course, anything to do with COVID-19, you come within one of these exceptions. And in the past, they all called it a national interest, but there was never really a definition for it. And now we are beginning to hear better explanations as to what might be in the national interest. So that concerns, and I'm very, very pleased to report that it concerns all students and academics. So if you are a student overseas wanting to come back stateside to resume your studies, that is now in the national interest. And if you don't have your visa, that visa can actually be issued by way of an emergency appointment in the consulate or embassy that has jurisdiction over your place of residence. The same goes for academics. And by academics, we are talking about typically J1 visa holders or applicants for J1 visas who are either short-term or long-term scholars and researchers, anyone who is engaged in faculty in our institutions. So that's really, really good news. In addition to that, we have in the past seen the wording in the proclamations, anything which is in the benefit of the economic recovery for employment creation and what have you, would be in the national interest, but it has never been defined. So now we are getting better explanations of that, and I think I have implored on you in other webinars and my newsletters that E2 treaty investors and E1 treaty traders come within the purview of these exceptions, because we know that our E2 treaty investors and E1 treaty traders most definitely do contribute to the economic recovery here in the United States. And in addition to that, that includes persons who need to travel stateside in connection with investment or trade that generates a substantial economic impact in the US economy. So that's a very broad definition, and the broader it is, the easier for me to fit you into some of these categories. In addition to that, what is in the national interest is senior level managers and executives who are essential for a business's success. Remember, the last proclamation excluded L1 intracompany transfers, L1A executives and managers, L1B specialized knowledge workers. Well, if I can show that their work is in the national interest based on this definition, I think that we could still get an emergency appointment, or likely to get an emergency appointment for the issuance of an L1A or L1B visa if that has not been issued on or prior to June 22nd of 2020. And then in addition to that, there are technicians and other specialists that engage in the installation, engage in maintenance of machinery, training United States staff to work on machinery, to work on certain installations that foreign national companies have installed here. So if you were to bring this back to its simplest component, if you work for a business that's outside the United States and that business has sold equipment, machinery, construction, whatever it may be, to a business in the United States, and for the United States business to commence or to continue operations with their foreign equipment, machinery, and so on, if that requires the maintenance, installation, and training by foreign national experts, well, those would be the people we could get emergency visas for, because what they do is in the national interest. So those are really, really good news. And if you think you come within the purview of something like that, I'll be happy to have a more extensive discussion with you on that. And that's it for the good news. I mean, you would think if you talk about immigration, it can't all be good news. So here's what's going on stateside. We have a USCIS printing disaster. And here's what that means. In the past, the USCIS had an outside vendor who printed all of their green cards and who printed all of their employment authorizations. And I don't know why, but the USCIS decided to bring that job in-house. And the minute they did, they didn't know how to print or couldn't print fast enough or are not printing fast enough. So what we have here is the USCIS has a 50,000 green card backlog in shipping out green cards because they haven't been able to print them. They have a 75,000 employment authorization document backlog because they're unable to print them. And that causes, of course, a horrendous dilemma, not only in the I-9 context, but for anyone who really needs their green card to work, to travel, to show ID, or for anyone who needs their work authorization to actually be able to work legally in the United States. So, you know, if you're an employer and you have someone coming in and they claim they are a permanent resident and they can't show it because, you know, the USCIS has not issued their green card, that's, of course, a very, very unfortunate circumstance. Also, someone not with a green card, some person here with a visa who is authorized to work in the United States may have to show an employment authorization. Many of you know that not all visas with which you can work have a work authorization which is incident to status. For example, an E2 investor can work incident to status. An L1 intracompany transferee can work incident to status. They do not need a separate employment authorization. However, their spouses, an E2 spouse, an L1, L2 spouse, they need employment authorization in order to be able to work. And right now, the USCIS, while they approve those, they're unable to send them out because they don't know how to print them. Some of those applicants do have a 180-day grace period, such as, you know, H-1Bs, H-4s, and so on. But for example, a DACA recipient has to have his employment authorization card in hand in order to be eligible to work. So I'm just throwing it out there so you know what's coming. You know, in the past, an employment authorization took about 90 days to be issued by the USCIS. Now it takes way longer than that, and here's the reason why: they don't know how to print them. Another thing that's looming, and I hope that our Congress, you know, can get off their chairs and actually get this thing moving. Many of you know that the USCIS is self-funded. They get their money from you, the immigrants and the visa holders, when you pay your filing fees. That's how the USCIS operates. They operate like a business. Now, because there are so few applicants, they are running out of money. And they will be running out of money within the next couple of weeks. They have, in time, several months ago, asked the Congress for $1.2 billion by way of a bridge loan or just emergency funding so they can sustain operations and do what they have to do. Now, if they are not funded within the next couple of weeks, they will have to furlough 70% of their workforce. That's 13,400 workers at USCIS. So you can imagine, you know, what the mood is in these offices. It's not very good, as you can figure. And that will happen by August 3rd. So even if, you know, even if the Congress, which if they do, some always does it in the last minute, even if they fund it on August 3rd, it'll already be too late. Then they'd already have to furlough people for 30 days, you know, before they could take advantage of any emergency funding. And, you know, I gave this some thought as to what might happen if this really comes to pass. Of course, the USCIS field offices have just reopened on, I believe it was June 4th or June 6th, and they would probably have to cancel all of their naturalization, their citizenship ceremonies. They probably will no longer have interview appointments, and many of you know, I know, are waiting for appointments there in order to get your immigration benefit, because appointments are required in some instances. There will likely be no info passes, so we won't be able to find out statuses of cases in the local offices and things of that nature. Now, in the USCIS service centers, there will be selective processing. There's no question about it, because they won't be able to process all the applications. Do I know what they will process? I don't. I can guess. I think it'll be all the things that are in the national interest. So maybe the applications of healthcare workers, applications of E2 treaty investors, E1 treaty traders, EB5 applications, things of that nature. There will certainly be an elimination, again, of premium processing. That's typically the first thing that goes away. And then, you know, we will likely experience additional backlogs if the USCIS service centers really have to furlough their employees. But I'm still hopeful that funding will be there timely. So there you have it. This is your update.